Good afternoon. Okay. Today we're going to talk about the topic of understanding educational law and how specific landmark cases help shape these laws. Okay, the type of topics that we are going to talk about are how landmark cases, all right, set the precedents, all right, in specific topics. The topics we're going to talk about are students' rights, teachers' rights, school safety, all right, discrimination and equitable actions, special educations and disabilities, and student conduct and discipline. All right, some examples of what landmark cases are and what they do. They establish a significant new legal principle or concept, or otherwise that substantially changes the interpretation of existing laws. So specific cases, all right, they might, there might be a law in place, and then these landmark cases change that precedent or change that law or policy moving forward. Okay, some examples are parents' involvement in community schools versus Seattle. All right, this decision took away that college laws or laws pertaining to certain educations and certain universities does not pertain to public schools. All right, in Abington School District versus Shemp, this really dealt with public education and how prayer, all right, is unconstitutional and forcing students to do that. And we will hit that later in another case, all right, later in these laws. Okay, the first thing we're going to talk about is how student rights, all right, in landmark cases. Tinker versus Des Moines Independent School. Our students were told they could wear wristbands with peace signs on them to protest the Vietnam War, stating, all right, the Supreme Court ruled, all right, that they were allowed to do this because of their First Amendment right and freedom of speech. Now, this sets the precedents to today, or how students can support different groups, all right, different subgroups and all that like that. Schools cannot say, all right, you can't wear that, or you can't do this, or you can't post that, all right, because of their First Amendment rights. All right, teachers' right. Gavon versus Western Lane Consolation School District. Okay, Gavon was fired for complaining to her principal, all right, about discrimination in her school. This ruling stated that the principal that educators do not give up their First Amendment protection because they're communicating on matters of public concerns with their principal. So if I would go to this says the president, if I would go to my principal and say, I don't like this about the school, I think we need to do this, or a student or other educators doing this, all right, they can't fire me just because of my First Amendment rights. All right, the next one, school safety. All right, United States versus Lopez. The 12th grade student in Texas was caught having a gun on him and was charged under the Gun-Free Zone Act. Okay, he was given 6 months in prison, and 2 months of probation. The student appealed this under the Commerce Clause. All right, and one of the closest readings of the Commerce Clause, since the court struck down the law and ruled that the Congress had exceeded its authority. This was vital because it caused the Congress to rewrite the Gun-Free Zone Act of 1990. So this president made them change the ruling, all right, and make it better, all right, and safer for people in the future. Okay, all right, discrimination and equitable actions. Okay, Engel versus Vitale. All right, this case shaped understanding of how the Establishment Clause of the First Amendment restricts prayer in public schools. Okay, this was vital because this court stopped a New York State rule that allowed public schools to say a non-denominational prayer at the beginning of school day. All right, so this law, all right, is impactful today, all right, in telling schools, all right, that they are not allowed, okay, they're not allowed to force students to pray, or they're not allowed to say non-denominational prayers, say after the Pledge of Allegiance or after other specific things. All right, so that this is vital, all right, because, all right, this protects people's religion, all right, sets the precedent, all right, for what is going on, all right, in public schools today, the separation of school and the separation of religion. Okay, special education and disabilities. Board of Education versus Raleigh, 1982. All right, Raleigh was a hearing impaired student, all right, who was in generational educational classroom. The school provided all the necessary things for students to be successful. All right, but the parents argued that she needed an interpreter, all right, for her schooling to meet the needs. All right, now The Supreme Court overturned this rule that said that they do need an interpreter, saying, all right, she was receiving free, appropriate education. All right, now the way the Supreme Court overturned this, they used her grades, all right, and her progress, saying she met the needs and she was at the limit, okay, all right, or she was making progress, all right, just at the rate or better than the students in that grade, okay, all right, and they also. All right, they also used her grades. She was passing. All right, she was meeting needs. She had good grades. Okay, just some simple rules like this. This case was a big step because it was the first time, all right, the Supreme Court used this act, all right, to make a ruling. All right, student conduct and discipline. New Jersey versus TLO 1985. The principal searched the purse of a student who was caught smoking and found junk paraphernalia in it. All right, now, the student claimed that the purse should not have been a reasonable search, which the Supreme Court upheld in the student's favor. This case was very, very important because it states that the Fourth Amendment prohibition of unreasonable search and seizures is not limited to actions of law enforcement. It also applies to the conduct of public school teachers. All right, public school teachers act as agents of the state and not agents of students' parents. Okay, so it gives them that right to search and seizure if seen fit. All right, but there's a fine line, all right, that us as educators need to do. But if we feel like, all right, hey, we got to search this for the safety of our school, all right, we're allowed to do so. All right, now these are our references, all right, that were used, okay, all right, in this presentation. All right, now, okay, these landmark cases are huge, all right, for us as educational leaders and principals. All right, we must use these laws set in place that these gave us, all right, to make the best thing, the best judgment possible, to make the best decision possible, to set policies in place to make the school, all right, the best place for us. So we must use these landmark cases, all right, that drove these policies and laws, all right, to make the school the best place possible for our students. All right, thank you and have a great day.